Kyle Anderson. And you're Justin Kyle Anderson, appearing there on the screen, marked J. Anderson.
Yes, sir.
All right. This hearing is being conducted by Zoom. Mr. Anderson's appearing as indicated on the screen, marked J. Anderson. Right, let's see. Who is Mr. Anderson? Mr. Rapp, you're Mr. Anderson's attorney, right? You're muted.
Your Honor.
Pardon me?
Your Honor, if I may, it's Mark Weisor.
Okay.
916, I'm co-counsel with Mr. Rapp.
Oh, okay, so both of you are counsel. I got you. All right. All right. Both of them are appearing by Zoom. And then appearing on behalf of the state is Assistant Prosecutor King. Now, the defendant is charged along with 6 other co-defendants in a number of charges. I believe Mr. Anderson is charged in counts 1 through 26, which are, thank you, felony indictments, and then also in count 32, along with a Mr. Zuber, which is a forfeiture. And the matter is set today for a plea hearing at the request of the parties. Counsel, both of you and Mr. Anderson in agreement that this plea hearing can be conducted remotely using Zoom rather than through an in-person appearance in the courtroom.
Yes, Your Honor. Yes.
And Mr. Anderson, you're all right with that?
Yes.
All right. Mr. Anderson, since you're not sitting in the courtroom next to your attorneys, if at any time you need to consult with them, you tell me, and I can then put you and them into what's called a breakout room on the screen. It'll be just you and those two. No one else will be able to see you or hear you, and your conversation won't be recorded. It'll be totally confidential, okay? All right. Now, Mr. Anderson has indicated this matter is set for plea hearing. I've been presented with a plea of guilty form. Looks like that is about 4 pages. And I'm going to hold up the first page, cover page. It has your name, case number, and a plea of guilty. It looks like it says it's proposing you plead guilty to counts 1, an amended count 9, 16, and 32. So I'll hold that up to the camera and ask you if you recognize that cover page, the first page of the plea agreement.
Yes, sir, I do.
All right, now on page 4, about halfway down the page, there's a sentence that reads, "I entered this plea voluntarily." Immediately below that appears to be the signature of Justin Anderson. Then I see your attorney's signatures to the right and the prosecutor's signature below yours, or what I think is yours. I'm going to hold that up to the screen and ask you if that is, in fact, your signature there under that statement says, "I entered this plea voluntarily." All right. And when did you sign this agreement, Mr. Anderson?
It was last Thursday.
Okay. And I might indicate for the record that this is actually a fax copy, and the only original signature is Annika Collins, this prosecutor. But counsel, these are replicas or the true copies of your signatures and that of your client?
Yes, Your Honor.
Okay. All right. Now, Mr. Anderson, when you signed this agreement, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And did you go over this with your attorney and have them answer questions, explain everything to you before you signed it?
I did.
And was this the result of some ongoing discussions over a period of time between you and your attorneys?
Yes. Yes. Yes.
And did you have enough time to fully consider the matter before making this decision?
Yes, I did.
And did you sign the agreement voluntarily?
Yes, I did.
Now, since it was signed last week and today's Monday, there's been a few days for you to ponder this. Do you still want to go forward with this, or are you having any second thoughts?
I still want to go forward with it.
You wish to go forward?
Yes. Yes, sir.
Okay, thank you. Your nose bleeding there?
I cut myself in the shower earlier.
Oh, okay, well, all right, so if you have to cover your nose, I understand. All right. All right, now, Mr. Anderson, the agreement states on page 1 that you're going to withdraw a not guilty plea, plead guilty to count 1 under 2923.32A1, engaging in a pattern of corrupt activity, and that's a first-degree felony. Amended count 9 of aggravated trafficking in drugs, Adderall, under 2925.03A2, a second-degree felony. Count 16, trafficking of marijuana in the vicinity of a school zone, under 2925.03A2, a second-degree felony. And then count 32, forfeiture specification, under 2923.32B. Now, with regards to the penalties for this, the first page also shows a provision that explains the penalties. And it says that you're understanding that the maximum penalty for each count would be as follows. In count 1, the maximum penalty is 3 years. That's ordered by the judge. The minimum is 3. The minimum is 3, and the maximum is 11, as set by the judge. So that is the actual range that the judge orders. Now, under the law, for this offense, the adult parole, or I'm sorry, the Department of Rehabilitation and Corrections can, at their option, actually extend that sentence by up to 50% of whatever sentence is imposed by the judge, based upon their analysis of the case. And so, in order to understand what the maximum penalty is, assuming the worst case scenario, if you were to receive 11 years imprisonment from the court, then that means that if the DRC decided they should do it, they could extend that to actually 16 and a half, because 5 and a half is half of 11. Add that to 11, you get 16 and a half. So that means that the penalty could be 11 to 16 and a half. Now, if it were the minimum sentence of 3 years, then the penalty could be extended by a year and a half, that being half of 3. So that means the maximum could be 4.5 years. So it would be 3 to 4.5 would be the minimum. And that's the way it works, each number through that range. You know, whatever the court sets is the minimum, and then and it is mandatory, by the way, and then the adult parole authority would have the authority to extend that further if they wanted by up to 1/2, or whatever number of years the court imposes as the minimum sentence. You understand that?
Yes.
All right. Now, for that offense, there's also a fine of $20,000 available in addition. Now, with regards to amended count 9, I think currently it is actually charged as a first-degree felony, and we'll get to how that's going to get to a second degree in a minute, but I believe it's probably going to be a deletion of something or a reduction or change in the language. But in any event, that penalty, as well as 16, are both second-degree felonies. Second-degree felonies, in these cases, are also mandatory offenses or sentences, and the range that could be imposed by the judge starts at 2 and goes up to 8. And then again, whatever number the judge imposes could be extended by up to 1/2 by the Department of Rehabilitation and Corrections, if that were the sole level of offense. And so it would work the same way as count 1 does. Do you understand that?
Yes, I do.
And there's also a fine available of $15,000, mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years on counts 9 and 16. You understand that?
Yes, I do.
Now, to explain further regarding the increase in sentencing by DRC under the Reagan-Tokes law, is what we refer to it as. If you have more than one offense for which that's possible, they can only do it on one, which would be the most serious. And so even though in counts 9 and 16, the law would provide for an extension of a maximum sentence of the court of 8 years to 12. In this case, if you were to be sentenced on all 3, they can only do it on 1, and they would do it on the most serious, which would be count 1. So you would only be looking at the 1 extension of time. You understand that? All right, now, accumulating these to understand the maximum possible prison term, 3 years is the minimum in count one. And so that means that's the minimum sentences possible for all offenses. The maximum, it looks like in this case to be set by the court, could be 27 years because you have 11 as a maximum on count one and 8 as a maximum on counts 9 and 16. So that's a total of 27 years. So your sentence could range anywhere from 3 years up to 27 years as set by the judge. And if the 11 was the maximum, that means it could be added another 5.5, so that could make it a maximum of 32.5. You understand that?
Yes, sir.
All right. Now, are you facing any other felony charges anywhere else, Mr. Anderson? Pardon me?
Yes,
Okay, and where is that?
Florida.
All right. Not in Ohio, though?
No.
Okay. All right. Well, I can't tell you anything about a Florida law as far as whether if you were convicted down there, the sentences could run consecutively or not. That's something I'm not able to determine. That's something you would have to find out on your own if you should, in fact, be convicted down there. I assume that you discussed those with your attorneys.
Yes.
Okay. Now, other than that charge and these charges, are you on felony, probation, community control, parole, or post-release control in Ohio?
No.
Okay. And again, there's nothing in your agreement about community control or probation because under the law, these whatever sentence is imposed on these 3 charges is mandatory and must be served. Now, any extension on count 1 of up to 5.5 years, that's not mandatory. That would be up to the DRC. But the court, there's no reduction of your sentence for any sentences imposed by the court in this case if you plead guilty. You understand that?
Yes, I do.
All right. Now, okay, count 1 reads that on or about the period of May 1, 2022, continuing through October 2, 2023, in Highland County, Ohio, and as a continuing course of criminal conduct, you, Travis James Zuber, and other unindicted co-conspirators did recklessly, while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity. In at least one of the incidents of corrupt activity is a felony of the first, second, or third degree, in violation of section 2923.32A1 of the Ohio Revised Code. So that's the first count, the first degree felony, with the penalty I just described. Now count 9 currently reads that on or about May 19, 2022, in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute Adderall, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk, less than 50 times bulk, when you knew or had reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another person. And currently that says in the vicinity of a school zone, and what I'm seeing here on page 2 that I'll cover in a moment is that that's going to be reduced from the current F1 down to an F2 by deleting the last part of the sentence, which reads, in the vicinity of a school zone. You understand that?
Yes.
All right. Young man, take off your cap there, please. Thank you. All right, then count 16 alleges that on or about September 12, 2022, in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, or prepare for distribution or distribute marijuana, a Schedule I controlled substance, an amount equal to or exceeding 1,000 grams, but less than 5,000 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another person in the vicinity of a school zone. So that's also a charge of trafficking of marijuana, a second-degree felony. Now, count 32 alleges that following property was used in the course of or intended to be used in the course of a violation of section 2923.32A1, or the property was used in, intended for use in, derived from, directly or indirectly, or realized through conduct of violation of ORC 2923.32A1, and any interest that you had, along with Mr. Zuber, is subject to forfeiture. And that lists 9 items: a 9mm Taurus and a magazine with 11 rounds, $20,393 in U.S. currency, 2007 Honda Accord, 2012 Chevy Silverado, a Honda motorcycle, a 2019 Dodge Ram truck, a 1999 Lexus, and a 1998 Tracker. Now, there's no the penalty for that is the financial loss of those items. There's no additional fine nor any jail time. This penalty is the loss of those items. Now, Mr. Anderson, do you understand what it is you've been charged with in each of those counts of the indictment? Count 9 as amended, and what it is the state said you did as to each count, when, where, and how they allege you did it?
Yes, Your Honor.
Now, have you discussed the nature of each of those offenses, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at a trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
But I should say attorneys, you have co-counsel here. And are you satisfied with their advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
Has anyone threatened you to make you plead guilty to the charges in the indictment that we're discussing?
No, sir.
All right, now on page 2, there are quite a few lines that are printed in bold and underlined, which are the substantive portions of the plea agreement, and I'll read those as follows. Defendant shall enter a plea of guilty to count 1. Count 9 is amended to a felony of the second degree by removing the language, the offense was committed in the vicinity of a school zone. Count 16 and count 32. State will dismiss remaining counts. State and defense jointly recommend 4 years mandatory incarceration on count 1, consecutive to 4 years mandatory incarceration on count 9, consecutive to 3 years mandatory incarceration on count 16, for a total term of 11 years, mandatory. Defendant agrees to forfeiture outlined in count 32 with the exception of item 6, 2019 Dodge Ram truck owned by co-defendant. Defendant agrees to forfeiture of all property seized during a search warrant executed at defendant's residence in October of 2023, and the state agrees not to pursue charges related to said search warrant. Okay, now is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, ma'am.
And again, you understand that as far as the 11 years that's being mentioned in the plea agreement, that could be extended as to count 1 by up to 50% of whatever term is imposed by the court. You understand that?
Yes, sir.
Now, under the law, Mr. Anderson, the matter of sentencing is up to the judge, not the parties. And so even though the agreement is that there be a term of 11 years of mandatory incarceration imposed by the court, I'm not required to follow that. If, after hearing all the information that's presented, I determine that that's not the appropriate sentence, I can sentence you to any sentence between the range of 3 years and 27 years, as we discussed in the earlier portion of this conversation. Do you understand that?
Yes, I do.
Mr. Anderson, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, I don't.
All right, now you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have the right to counsel and you have hired co-counsel in this matter. Now, in the event that you did not have money or the funds to continue to pay your attorneys, then you would qualify for appointment of counsel by the court at no cost. And so the reason I bring that up, I'm just trying to make sure, for the record, you're not entering into the agreement to plead guilty simply because you feel you will not have the money to continue to hire them to represent you.
No, no.
All right. Now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. And once they are selected, the 12 of those people are selected, the evidence will be presented in the trial, and the court would instruct that jury on the law. And then that jury of 12 people would then decide whether or not the state proved your guilt on any of these 3 counts. And that decision would have to be unanimous, meaning all 12 of them would have to agree on a verdict as to each count. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt on any of the 3 counts. Do you understand that?
Yes, I do.
All right, now, Mr. Anderson, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorneys. What that means is that the witnesses against you have to come into court and testify as to, excuse me a second here. What was that now? What is it? Oh, okay.
Marshall, you think we're still going to Zoom it or should it be in person?
We'll Zoom it.
Okay.
All right, now, again, I'll go back up because I'm not sure I covered everything thoroughly. You have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in open court in front of you, your attorney, and anyone else that's present. And the purpose of that would be to bring out any evidence that helps your side of the case. You understand that?
Yes, yes, sir.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily at your request, the court will issue a subpoena that forces those people to come into court to testify on your behalf, even though they don't want to be here. And that is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you have a privilege against self-incrimination. And what that means is that you cannot be forced to give evidence in this matter or to testify in the case at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, at any time, by anyone in the proceeding. And in fact, no one can even comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right, now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each of the charges. What that means is that the burden of proof isn't on you to try to prove that you're not guilty of these charges simply because you've been accused. In fact, under the law, you don't have to present any evidence at the trial to defend yourself. You may, but you're not required to. Whether you present any evidence in your own defense or not, the burden will remain upon the state of Ohio to prove your guilt on every essential element of each of the 3 charges by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty. The not guilty plea denied your allegation in the, against you in the indictment, denied you committed any crime, and it exercised all the rights that I have just described. If you change your plea today from not guilty to guilty, that is the complete opposite of the not guilty plea. Guilty plea admits the allegation in the indictment, admits that they're a crime, and that you committed that crime is in those 3 counts, with count 9 being amended. And that plea, as to those 3 counts, waives or gives up all rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your right to confront the witnesses against you, because if you say you're guilty, it would waive or give up your right to require the state to prove your guilt by proof beyond a reasonable doubt, because if you plead guilty, the state doesn't have to prove you're guilty. Now, a plea of guilty subjects you to being sentenced immediately by the court. Finally, it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. Any appeal that you would file would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
Mr. Anderson, are you a U.S. citizen?
Yes, I am.
Now, do you have any questions about the charges? Well, let's say count 1. Do you have any questions about count 1 or the possible penalties for that?
No.
Okay. Do you have any questions about count 9 as amended or the possible penalty for that?
No, I don't.
And do you have any questions about count 16 or the possible penalties for that offense?
No, I don't.
Or as to count 32, the forfeiture?
No, sir.
Okay. Now, do you have any questions about the plea agreement?
No.
You understand it?
Yes, sir.
And again, you understand that the sentencing recommendation of the parties is not binding on the court,
Yes, I do.
right? You have any questions about the constitutional rights I've explained to you?
No, I don't.
You understand them?
Yes, sir.
You have any questions about the plea of guilty, what it means, or what will happen if you exercise that, or if you enter that plea here today?
No, I don't.
You understand that?
Yes, I do.
Now, is there anything you need to talk with your attorneys about before we go any further?
I don't think so, no.
You have any questions about anything that I've explained to you here today?
No, sir.
And counsel for defense have anything you'd like to say or talk with him about before we go any further?
Nothing from the defense, Judge. Thank you.
All right. Then, Mr.
If I may, there's just, sorry to interrupt, there's one thing I did want to make clear. At the last page of the plea agreement, you'll see a list of property that is forfeited, and that's from the October search warrant. I just wanted to make sure that was clear and on the record.
Okay.
I added this morning after I consulted with defense counsel.
All right. So, counsel, you have the 3 items that are listed or attached to the agreement. That's a $19,963 in currency, a Hyundai car, and a Jaguar car.
That is correct, Your Honor. Mr. King forwarded that to his intentions today. We have no objections to it. Thank you.
Okay. So that's understood on the record then, Mr. Anderson, that that's the additional property being forfeited that's referred to on the plea agreement that I read to you.
Yes, sir.
Okay. And you're agreeing to that?
Yes, I am.
Okay. All right. Then is it your decision to withdraw your not guilty pleas to count 1, count 9 as amended, count 16, and count 32, and enter a plea of guilty?
Yes, sir.
Then as to count 1, that alleges that on or about the period of May 1, 2020 and continuing through October 2, 2023, in Highland County, Ohio, and as a continuing course of criminal conduct, you, Travis James Zuber, and other unindicted co-conspirators did recklessly while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity, and at least one of the incidents of corrupt activity is a felony of the first, second, or third degree, in violation of Section 2923.32A1 of the Ohio Revised Code, the charge of engaging in a pattern of corrupt activity, a first-degree felony, carrying a possible prison term, mandatory prison term, imposed by the judge of between 3 and 11 years, with a maximum being added of up to 1/2 or 5.5 years if it's a maximum sentence, a fine of $20,000, and again being a mandatory sentence. How do you plead? I'm sorry?
Guilty, sir.
All right, thank you. Now, as to amending count 9, which has the last portion, the last clause in the indictment deleted regarding it being in the vicinity of the school, but otherwise, count 16. The reading as follows, as amended. On or about September 12, 2022 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute marijuana, a Schedule II controlled, wait a minute, I'm skipping over that. I went to 16 instead of 9, sorry. Let me start over. Hold on a second. Hey, Ben. They haven't, are they going to bring him up? Okay, he's still sitting out there. Okay, all right. All right, then as to amended count 9, which reads that on or about May 19, 2022 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute Adderall, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another person, in violation of Section 2925.03A2 of the Ohio Revised Code, the charge of aggravated trafficking in drugs, a second-degree felony, carrying a possible or a mandatory prison term of at least 2 years up to 8 years as ordered by the court, fine of $15,000, and a mandatory fine of $7,500. How do you plead?
Guilty.
Then as to count 16, which alleges that on or about September 12, 2022 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute marijuana, a Schedule I controlled substance, an amount equal to or exceeding 1,000 grams, but less than 5,000 grams, when you knew or had reasonable cause to believe that controlled substance was intended for sale or resale by the offender or another person, in violation of Section, in the vicinity of the school zone, in violation of Section 2925.03A2, also a second-degree felony carrying a mandatory prison term of between 2 and 8 years, and a fine of $15,000, mandatory fine of $7,500, and also a possible license suspension for both count 9 and count 16 of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 32, which alleges that the following property was used in the course of or intended to be used in the course of a violation of Section 2923.32A1, or the property was used in, intended for use in, derived from, directly or indirectly, or realized through conduct in violation of RC Section 2923.32A1, in the interest of you, subject to forfeiture pursuant to RC 2923.32B. And that would be items 1 through 9 I read to you earlier, with the exception of number 6 is owned by the co-defendant, which would result in the loss of all those items to the state, as well as those 3 additional items attached to the entry from a search warrant that's not part of the charges here. How do you plead?
Guilty. Is that
Yeah.
forfeiture? Is it?
Forfeiture, yes. Yeah, the forfeiture.
Guilty, yes.
All right, thank you. All right, the court finds on this date, open court, defendant was advised of all of his constitutional rights. Defendant was waived all of those rights and entered a plea of guilty to voluntarily, knowingly, and intelligently to each of those three, counts, I should say, count 1, count 9 as amended, count 16, and count 32. The court finds the defendant guilty of each of those offenses as charged in the indictment, except as to 9, which is as amended. The remaining counts as to the defendant are dismissed. All right, now, in terms of sentencing, it's my understanding there was a hope it would be a delayed sentence, and that's why I agreed to go ahead and do this by Zoom, or do the plea today, but the sentencing will be in person. Is there a request for a pre-sentence investigation or just a sentencing date?
Just a sentencing date, Your Honor. Thank you.
All right. March 6th at 9 a.m. available, counsel.
Judge, I'm going to be in a jury trial in front of Judge Cole Reeser in Allen County that day. I don't know if Mr. Rapp would be available.
Mr. Rapp?
Thank you, Your Honor. I'm getting there. It seems to me that I thought I had Anderson.
We do by Zoom that day for a final.
Judge, I would be available.
All right, so that'll be in person at 9 a.m. All right, so your bond will be continued, Mr. Anderson, under the same conditions. And again, if you don't comply with those conditions, that could result in a warrant issue for your arrest. And again, since the sentencing recommendation is not binding on the court, obviously if you don't appear or do something else, that might have a bearing on the court's decision. So we'll make sure you continue to report and comply with those bond conditions. So it'll be at 9 a.m. March the 6th in person here at the court. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right. Mr. Wagner, Mr. King, we're having Mr. Hauser brought up to the courtroom. So he should be here in a few minutes. All right, this is case number 23, CR 222, State of Ohio versus Joseph Dylan Hauser. Present on behalf of the State of Ohio is Assistant Prosecutor King. Representing the defendant is Attorney Jacob Wagner. And are you Joseph Dylan Hauser?
Yes, Your Honor.
All right, this matter was set for a plea. Defendant is charged in a 5-count indictment, involuntary manslaughter, corrupting another with drugs, aggravated trafficking of fentanyl-related compound, and possession of fentanyl-related compound. Now, Mr. King, as a representative of the alleged victim as to count 1 and 2, been notified of the time, place, purposes of hearing, the right to be heard?
Yes, they have, Your Honor, and the victim's mother and father are both present in the courtroom today, along with, as you can see, many friends and family also.
All right, thank you. All right. The defendant was just indicted on this case on December the 5th. And I know there's been some discovery, and the matter was set for we had a first pretrial, and a matter set for a final pretrial on February 21st, with a trial set for March 11. Now, the court has been provided with a plea of guilty form, Mr. Hauser, which indicates you're going to withdraw your not guilty plea and plead guilty to count 1, which is involuntary manslaughter under 2903.04a of the Ohio Revised Code, a first-degree felony. And this is a 4-page form. At the bottom of page 3, the last sentence reads, "I enter this plea voluntarily." Immediately below that appears to be signature of Joseph Hauser. And is that your signature I'm looking at here on this plea agreement?
Yes, Your Honor.
When did you sign this agreement, Mr. Hauser?
Today around 10:30.
All right. Now, when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And did you go over this with your attorney and have him explain everything to you and answer your questions before you signed it?
Yes, Your Honor.
Do you think you had enough time to fully consider the matter before making this decision?
Yes, Your Honor.
Do you feel that you've been rushed or pressured in any way into doing this?
No, Your Honor.
Did you do this voluntarily?
Yes, Your Honor.
Right now, the agreement, as I indicated, says you're going to plead guilty to count 1, which is a first-degree felony. And under the law, penalties for that range from 3 to 11 years as set by the judge, with a maximum of up to 1/2 of whatever term the judge orders being added to that sentence. And so, if you are sentenced to the maximum of 11 years, then the Department of Rehabilitation and Corrections could, at their option, add up to 5.5 years, which is half of 11, to that sentence, making the maximum possible 16.5 years. If the sentence, minimum sentence was imposed of 3 years, then the Department of Rehabilitation and Corrections could add an additional 1.5 years for a total of 4.5 to that sentence. And so it works the same way for all those numbers in between. You understand that?
Yes, Your Honor.
There's also a fine available of up to $20,000. And under the law, this is not a mandatory prison sentence offense, but it is presumed, meaning that the legislature has said that, in their view, that would be the appropriate punishment, but it's still left up to the discretion of the court. You understand that?
Yes, Your Honor.
Now, other than the charges in this indictment, in this case, are you facing any felony charges anywhere else?
No, Your Honor.
And are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Now, if you are convicted for this offense and if you are sentenced to prison, upon completion of the prison term, it is mandatory that you be put under supervision of the Adult Parole Authority under what's called post-release control supervision. That means you'll be supervised by a parole officer under the terms set by the Adult Parole Authority. The court has no involvement with that. And that would be for a minimum of 2 years, and it could be up to a maximum of 5 years as determined by the Adult Parole Authority. Now, if during that period of time that you were being supervised, the parole authority found that you had not complied with those conditions, then they would have the right to make you go back to prison, to make you serve an additional period of up to 9 months for any single violation up to a maximum of half of the prison term that you serve for all violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge in that new felony case could impose upon you, that judge could also sentence you for committing that new felony while under post-release control, in this case, to an additional period of a year or whatever time was left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, as I indicated, the law doesn't require the court to impose a prison term for this offense, and so it is possible you could get what's called community control, or what most people know to be probation. What that means is that you would be put under supervision of the probation department for a period of up to 5 years under terms ordered by the court. If during that period of time the probation department thought that you were not complying, they would file a written notice of that with the court. There would be a hearing in which you would be entitled to be represented by an attorney. If the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of 11 years and fine you at $20,000. And if your community control was revoked or terminated because you had a new felony conviction, then you could, any sentence that would be ordered to be served in this case could be ordered to be served consecutively to the sentence in that new case. You understand that?
Yes, Your Honor.
All right, now, the charge in count 1 alleges that on or about the period of February 3, 2023, continuing through February 4, 2023, in Highland County, Ohio, you did cause the death of a person identified as V as a proximate result of your committing or attempting to commit a felony, to wit, corrupting another with drugs and aggravated trafficking in drugs, in violation of Section 2903.04A of the Ohio Revised Code. So that's the charge of involuntary manslaughter with the penalties that I've described for you here earlier. Now, Mr. Hauser, do you understand what it is you've been charged with by the state, what they said you did, when, where, and how they alleged that you did that?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs in the jail?
Yes, seizure medicine.
You have what?
My seizure medicine.
Anti-seizure medicine?
Yeah.
All right. Does anything about that medication interfere with your ability to understand what's going on here, to understand what you read and signed, or to tell me what your responses are?
No, Your Honor.
Okay. Now, has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2 of the agreement, actually page 3, there are a couple of sentences at the top printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss remaining counts. State defense jointly recommends 6 years incarceration. Now, is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Hauser, the matter of sentencing is up to the judge, not the parties. And so, even though there's an agreement by both parties that if you plead guilty, the sentence should be 6 years, I'm not bound by that. I could impose any sentence that I determine is appropriate under the law, including between 3 and 11 years. You understand that?
Yes, Your Honor.
Now, as far as the 6 years incarceration, again, that refers to what the court orders. Because under the law, the Department of Rehabilitation and Corrections could, after you serve 6 years, decide that you should have your penalty extended by up to 1/2, which means 3 possible additional years. So that means that the possible sentence could be up to 9 years, and the minimum would be 6 years, the maximum would be 9 years under the law. You understand that?
Yes, Your Honor.
Okay. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept this plea. First, you have a right to have counsel, and Mr. Wagner was appointed to represent you. since you did not have the funds to hire your own attorney. Now, his appointment wasn't simply to work the case out, but to try to provide any defense to you in court that is available under the law. So if you decide you do not want to plead guilty, that you want to defend against these charges, he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County, summoned for jury duty on your trial date. After those 12 were selected, the evidence would be presented, the judge would instruct them on the law. And then that judge would decide by that jury would decide by unanimous verdict, meaning all 12 of them, as to whether the state proves your guilt. So they would have to agree on a verdict either way, guilty or not guilty, and have to be unanimous. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial, and in that case you would have what's called a court or bench trial. And in that case, the judge would be the one who would hear the evidence instead of a jury, and the judge would apply the law, and the judge would be the one who would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Hauser, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present in the courtroom. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a subpoena, which is a court order. And that forces those people to come to court to be able to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or testimony in the case at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Hauser, you're presumed innocent of this charge and all the other charges, for that matter, until proven guilty by the state of Ohio by proof beyond a reasonable doubt on every element of the offense charged. What that means is the burden of proof isn't on you to try to prove that you're not guilty simply because you've been indicted. In fact, under the law, you're not required to present any evidence in your defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now, originally you entered a plea of not guilty. Not guilty charge, denied the allegations in the separate counts of the indictment, denied that you committed any crime, and it exercised or invoked all the rights that I've just described for you here today. Now, if I change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in count one, admit that it's a crime and that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses in open court and cross-examine through your attorney, waives or give up your right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. The waiver gives up your privilege against self-incrimination, because if you say you're guilty, then the state's not required to prove you're guilty, because that's what's used against you to find that. And then finally, it waiver gives up your presumption of innocence, because again, if you say you're guilty, the state doesn't have to put on any proof that you are. Now, a plea of guilty subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I were to sentence you to the maximum sentence in this case, or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, I am.
Now, before I go on, Mr. King, has the state consulted with the parents of the victim and considered their input into reaching this agreement?
Yes, Your Honor. Just to be clear for the record, the state has done so. I don't know that I would say that they approve of this agreement. However, the state has been in regular contact with both the mother and the father during the pendency of this case, and they are understanding of the agreement.
Okay. All right. Now, is there, I forget if are you a U.S. citizen?
Yes.
I didn't check it off. Okay, thank you. Now, do you have any questions at all about anything that I've explained to you here today?
No, Your Honor.
Do you need to speak to Mr. Wagner about anything?
No.
All right. Is it your decision then, Mr. Hauser, to withdraw your not guilty plea and enter a plea of guilty to count 1 pursuant to the terms of the plea agreement that we've just gone over?
Yes, Your Honor.
All right, then, as to the charge that alleges that on or about the period of February 3, 2023, continuing through February 4, 2023 in Highland County, Ohio, you did cause the death of V as a proximate result of Joseph Dylan Hauser's committing or attempting to commit a felony, to wit, corrupting another with drugs and aggravated trafficking in drugs, in violation of Section 2903.04a of the Ohio Revised Code, a charge of involuntary manslaughter, a first-degree felony, carrying a possible prison term of between 3 and 11 years set by the judge, the maximum of up to 50% of the term selected by the judge as a minimum, as the maximum, and a fine of $20,000. How do you plead?
Guilty, Your Honor.
Thank you. You can be seated. All right, the court finds that on this date, open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Please accept an order filed. Defendant's found guilty of count 1. Counts 2 through 5 are dismissed. Now, is there a request for a pre-sentence report?
No, sir.
All right. Then you're fine with going ahead with sentencing forthwith.
I am, Your Honor.
All right. Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. This is what I'll call a tragic case where the defendant sold to the 16-year-old victim what was believed to be a Percocet pill. In reality, this pill was not a Percocet. It actually contained fentanyl. And after ingesting the pill, the victim passed away. The state is asking that the court follow the joint recommendation and sentence the defendant to a term of incarceration of 6 years. As I've indicated, the victim's mother and father are both present in the courtroom today. The victim's mother, Melinda Dermer, would like to make a statement, and the significant other of the father, her name is Heather Newhouse. She has prepared a statement for Heather Collins to read, if the court would permit that.
All right. You want to go with the mother first? She want to speak? All right. You're going to speak on behalf of the father?
The father's a significant
All right,
other.
go ahead.
She calls herself the bonus.
What's the name?
Her name's Heather Newhouse.
Okay, thank you. Go ahead.
Jordan Grove was kind and caring. He would give you the shirt off of his back. More than half the kids at his funeral were wearing one of his hoodies. Jordan was fun and silly. Any chance Jordan got, he would crack a joke. Now, because of fentanyl, we will never experience this again. Jordan wasn't perfect, but he didn't deserve this. Watching Jordan's siblings and friends achieve new milestones wrings my heart like a wet dish rag. Jordan should be achieving these things too. The most upcoming milestone that tears my heart is his high school graduation. While his high school show so much sympathy and support for our family by providing a seat and cap in honor of him. Our hearts will break as we look at his empty chair. I feel sorry for Joseph's family. They're losing their son too, but they will get him back in just a few short years. We will never get Jordan back. The short sentence that Joseph receives, whether it be 1 year or 12 years, seems like a slap in the face and an insult to our family. I, of course, am partial. As much as I'd like to wish the worst on Joseph Hauser, I know that he too is someone else's son. I hope while Joseph is serving his time, he takes advantage of all the recovery programs in prison that they offer him. I hope he recovers and doesn't commit this same act again. I also hope he feels remorse and he finds God. I know that in the end, justice will be carried out through the court system and through God. We love and miss you, Jordan Grove.
All right, thank you. Will you state your name, ma'am, and
Melinda Derler.
go ahead.
How do I put 16 years into a few words? I'm not going to try to tell you Jordan was perfect. I'm a perfect kid. No one is perfect. He was a normal, ornery, curious 16-year-old boy. He loved cars and four-wheelers and dirt bikes, basically anything with a motor. He was going to Laurel Oaks, taking on a collision. He was very good at it. He was talking to body shops about working for them, and a couple were actually interested in how well he was doing in the lab. Jordan loved his friends and family and was not ashamed to show it or say it. He cared about people in general and did not like to see people sad. He would do whatever he could to cheer you up and had a way to get you to laugh and forget about whatever was troubling you, at least for a little while. I have heard several stories from teachers and other students about how Jordan would seek out new kids and befriend them, show them around, even offer for them to sit with him at lunch so they wouldn't have to eat alone. Then there are stories of some being sad because of losing someone, a loved one, or anything like that, and he would sit with them, hug them while they cried, or cry with them. He had such a big heart and would literally give you the shirt off his back. Many times I wondered why his lunch account was low or negative, and he would say, oh, so-and-so didn't have any money, or I got extra to share with some of my friends. When he played football and wrestled, there were very few days we weren't taking another kid home or waiting with them until their ride got there. Jordan wanted to save the world, even if it was one person at a time. Family was very important to him. He had older brothers and sisters, so he was used to being the little brother. So when he found out he was going to be a big brother, he was so excited. He could not wait for Gracie to get here. We have a blended family, and for the most part, we all get along really well. So Jordan didn't have to take sides, and he saw how family's supposed to be. We all love and support each other, and Jordan learned from that, and I'm so proud of how loving and respectful he was to others. As we all know, since we're here, Jordan made a mistake. We all have. But he was only a 16-year-old boy. We all did dumb things at 16. That's part of growing up and learning. But it shouldn't have cost him his life. Jordan had a plan for his future, and he was stubborn enough to accomplish whatever he set his mind to. This past year should have been ordering cap and gowns and other senior things. Instead, we ordered a casket and headstone. We, his family and friends and community, lost someone very special to us. Joseph Hauser, as much dislike as I have for you, and I have to say dislike because I was not brought up to hate anyone, even with what's happened. I hope you never have to go through what we had over this last year. The loss of a child is the worst pain I've ever felt. You took away my baby, my only son. 6 years is not enough. No amount of time will bring my son back. But 6 years is not enough for the future you took. And I hope that your child never has to face the same predicament that my child did, and I hope you never have to bury your child. Thank you.
Anything else you can state, Mr.
No, Your Honor, thank you.
Wager?
Yes, sir. Stand up. Before I begin, I want to offer my sincere apology to you guys. I think my son Jack from Jordan he came to his funeral. Some of the classmates back here, they all played ball together, so I'm sincerely sorry, guys. On behalf of my client, I know he is sorry as well. Taking the legalese out of this, Your Honor, this case just sucks. A young man's life was lost from a stupid mistake. Again, I agree with the mom. I was 16 one time. I don't want that coming out in a court of law either. So this should not be held against Jordan. But again, for my client's behalf, since day one, he's not sat here and tried to shift blame. He's not tried to take the guilt out of his camp and shift it towards this young man. He immediately took responsibility. I know that doesn't bring Jordan back, but it means a little, at least in my eyes. This guy is admitting to his wrongdoing. He's willing to do his time. I know the time that he does will not bring this young man back. But it is what, like I say, the law is right now in the state of Ohio. This is what we're kind of cornered into. These are the parameters of time that we have to look at. So again, my heart goes out to the family, to the friends that are here on his behalf. We just ask the court to follow the recommendation, Your Honor.
Mr. Hauser, anything you'd like to say?
Yes. I would like to say I'm sincerely sorry, and this wasn't supposed to be the outcome.
Well, I see from the record that you are just 24 years of age yourself. That's still very young, although significantly different than a 16-year-old. So, you know, why you've been involved with him, I guess it's because you're selling him drugs. You know, this is just a tragic example of what, you know, is going on in today's world with, you know, substance use disorder and abuse. And, you know, there's no truth in advertising. You know, we see more and more, almost none of the drugs that are being sold on the street are what they say they are. We even have marijuana that's laced with fentanyl and pills that are, you know, supposed to be one thing that are something else, fentanyl, most of the time, or worse, carfentanil, or the newest version with paracarfentanil. These things are deadly. And, you know, we all make choices, life and death choices in our lives. Unfortunately, well, that shouldn't be the case when you're 16. When you're 16 years of age, you know, choices you make shouldn't be of life and death. But unfortunately, you know, with today's world and all the information that you kids and all you folks here that are in the courtroom have, you know, you're exposed to a lot more temptation and danger than people my age were growing up. You know, the fact that you're all here, I think, is extremely impressive about what kind of person Jason was. But let me say, Harvey?
Jordan, Your Honor.
Jordan, I know I said Jason, another person that I knew that's deceased. That Jordan was a great young man. But I would hope that all of you being here would not just use that expression of your respect and support for him, but also carry it on in your lives in terms of doing what you can in your community with your friends to make kids stop taking drugs. You know, and the initial choice to take a drug is your own. There's no question about that. A lot of times it's because there are issues, you know, and we have problems, in particular when you're younger, and you think, you know, this is the worst thing in the world that's ever happened to me. I broke up with my boyfriend or my girlfriend, or, you know, my car, I crashed my car, and now I don't have a car. Oh, the world's coming to an end, and, you know, and things, you make bad decisions. We all do, and we all did. You know, those who have lived as long as I have, we're lucky that none of the choices I've made so far have caused my death. But, you know, that's what the world you're living in. And I hope that all of you will consider what is it you can do to make sure this doesn't happen again, because unfortunately it will, until our community and our world, our people in this country get to the point where they can deal with life without taking drugs. Because the problem is, once you start, the way they market these drugs, and they taint them with fentanyl and other things that are highly addictive, once you've made your own choice once or twice, your body takes over, and it's no longer free will. You know, that's what the tragedy is out there. But, you know, I don't think that by any stretch of the imagination, what I've seen, that Jordan was that kind of individual. But he made a bad choice this time, and unfortunately it was a deadly one for him, and it's just tragic, you know, and, you know, it's really hard to sit here and hear that for anyone. And, you know, I appreciate the parents' consideration and thoughts and, you know, compassion towards you. That's a hard thing to do. A lot of parents I see would just soon come through there and grab you by the neck and choke you to death. But again, you know, you've made mistakes as well, and it's been a big one. It's been a big one. I mean, there are other people I see all the time that are selling drugs, and people don't die. But, you know, people are selling drugs. Got to understand, every time you have a transaction, you could be causing somebody's death, because that you don't know what's in there, and even if you do know what's in, it may not be in the strength you think. You know, you may think it's this amount of fentanyl, and it's 10 times that amount, and just a little bit of fentanyl can kill somebody. And so, you know, it's just tragic. You know, nothing I can do can bring him back. Nothing I could do. The sentence would represent adequately the loss that the parents have suffered, and all of you that were his friends and family. But, you know, the law requires that we make a determination. You know, the law provides for a sentence between 3 and 11 years here. This recommended sentence is 6 years. Looking at your record, you have a relatively minor record, I think 1 misdemeanor and some other minor things. You know, previous felonies. I don't think any previous drug offenses, from what I can see, if I recall correctly. No, he had an OVI and a physical control, but you know, there have been no previous drug trafficking charges. So, taking a look at the weighing everything here, the judge, I am going to be following the plea agreement. So the judgment of the court is that you be sentenced to a term of 6 years as a minimum sentence at the Ohio Correctional Reception Center in Orion, Ohio. And that'll be the minimum sentence. That sentence can be extended by the Department of Rehabilitation Corrections at their option and discretion to up to 9 years by adding 1/2 or 3 years onto that as they determine. That's not mandatory. That'll be their discretion. You are arrested according to the sheriff's record here on December 6th. Is that correct?
Yes, Your Honor.
All right, so that'd be a total of 54 days of jail time credit. Now, upon completion of your sentence, Mr. Hauser, it is mandatory under the law that the Adult Parole Authority place you under what's called post-release control supervision for a period of at least 2 years, up to a maximum of 5 years. So you'll be supervised on the terms that they set. The court has no involvement with that. If you should violate those conditions during that period of time, then the Adult Parole Authority can return you to prison to make you serve an additional period as a sanction of up to 9 months for each violation, up to a limit of half of your prison term for all violations. However, if you should commit a new felony while under post-release control, in this case, then in addition, whatever sentence could be imposed by the judge in the new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, or whatever time is left on the period of post-release control imposed, whichever is greater. And if that occurs, that would have to be served consecutively to the sentence in the new case. You're also ordered to pay the costs for which the judge would grant execution is ordered. If you fail to do that, that can be collected by the clerk through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you could be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. And each hour you worked will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, sir.
All right, you're remanded to custody, Mr. Howland.